Thank you, everyone. We are so excited to have you here today to join us for this important conference. We are on the third panel for our After Dobbs conference. And today, this afternoon, we will be talking about the future of Dobbs, opportunities, activism, and creative rage. We are honored to be joined by a distinguished panel of experts. They will be sharing their insights, ideas, and experiences with you all today. And we look forward to an engaged question and answer session after their presentations. The members' bios can be found in the chat in just a moment. And we will ask all attendees to please use the Q&A function to ask questions. We are using Zoom captioning, and that we have two American Sign Language interpreters joining us today, and they will take turns every 10 to 15 minutes. And our ASL interpreters are Emily Jones and Aviva Ben-Treat. So I am delighted to introduce our panelists today. We are joined by Leila Abolfazli, the Director of Federal Reproductive Rights, the National Women's Law Center, and District Attorney Sherry Boston of DeKalb County, Georgia. Caitlin Chin, Fellow, Center for Strategic and International Studies. Victoria Nourse, Professor of Law, Georgetown University Law Center. Elizabeth Platt, Director, the Law, Rights, and Religion Project at Columbia Law School. And Anna Rupani, Executive Director and Advocate from Fund Texas Choice. So we are delighted to begin today with remarks by Leila Abolfazli. Leila?
Thank you so much, Kristi, and thank you to the interpreters as well. Thank you for doing this, and for Georgetown for putting on this important event in the middle of a beautiful, gorgeous day in this almost fall, but to talk about something very serious and central to the functioning democracy. As Kristi mentioned, I'm Leila Abolfazli. I'm Director of Federal Reproductive Rights at the National Women's Law Center. I've been doing this work for more than a decade, and really started it right as things went into overdrive in the effort from the anti-abortion movement to ultimately overturn the right to abortion. So I'm going first because my last name starts with AB, and ever since elementary school, that has meant that I go first. So I'm going to use this opportunity to help frame the conversation about the need for clarity of our through line from activism to policy with a backdrop of a shifting society. So when we look ahead, as this panel does, it actually asks what each of you are going to be doing. This is about our opportunities, our activism, and our creative rage. So to take a moment about talking about moving forward, let's talk about how we got here, which I know you've actually had in full panels on this, so I don't need to take long, but the moment we're in with losing this constitutional right to abortion is that rooted in that we have not fully reckoned with our country's history of racism and sexism. I was listening to a podcast that had nothing to do with any of this over the summer, and one of the podcasters just mentioned on this just randomly that gender is so retrograde in this country, and what a personification of that we are experiencing right now. So how do we move forward given what we haven't yet done and reckoning with these major pillars of our society, and how do we move forward, and how does creative rage fit into that? I think it would be important to note that we still, as a society, have not figured out how we coexist with social media, and that there are benefits and negatives, and how do we make sure that the benefits are outweighing those negatives. And quite frankly, there are a lot of days when I feel like we have lost that battle. On other days, though, I see its power and its ability to change things. I think about how one incredible advocate, Olivia Juliana in Texas, raised millions for abortion care, turning political misogyny into positive activism. So we're contending with this as a society, and then we look at us. I assume many of you on here are lawyers or soon to be lawyers. How do we fit into this? Particularly because of how we are trained and raised as lawyers, and how all of that seems to have been pulled from under us this summer. What I mean is the anti-abortion movement got here by not following any of the rules. They passed laws that clearly violated the law over and over and over again. They got justices on the Supreme Court that bent their own rules to give them a path, to give them what they want. And now we are having central questions to what our country is, talking about the right to travel, preemption, federalism. So this summer really sparked the chaos, and indeed we'll take a look back. Actually, the year before really sparked the chaos when the Supreme Court green-lighted Texas's terrible bounty hunter law that allowed people, your neighbors, to go after you related to abortion care. So I think about this all the time as a lawyer for 15 years. What is our role in this, given how the law has been weaponized against people who need abortions, who provide abortions, who support abortion? And what are we supposed to do when we were told to believe in stare decisis, that you build your arguments and your cases based on the cases that happened before you? And when all of that kind of gets pulled from under you, what does that mean for our daily practice of law? Now, I'm not a litigator. I'm a legislative lawyer, and a nerdy one at that. And I still believe in the law, but I think that it is time to reassess what it means to be a lawyer in this time. And how do we move forward as one of the pillars of our democracy, and what it means. So I can tell you that whatever it is, don't let it be. Don't do that. Law, often we tell ourselves we can't do that. And I think we're at the point where if we are dreaming a new future, which quite frankly, if there is one silver lining, which there absolutely is not from the Supreme Court overturning the right to abortion, but if we are thinking about what that meant to us, it means to us lawyers that indeed nothing is painted in stone. So that means nothing is painted in stone. And the things that we told ourselves before, we can't do that, or that's not how we are, or that's not how law should be, all of that is out the door. So if nothing is set into stone, how do we embark future? How do we as lawyers dream as part and along with the advocates for abortion care, the providers, friends and family, politicians, everyone who's laser focused on abortion care today? So I frame this about lawyers, given the folks we have on this panel. We are obviously a piece of the bigger conversation, but not the only piece. And so it's always important to remember that. And remember, as lawyers, we are advancing the interests of the people we represent. And so as we think about how scared people are across the country after the Dobbs decision this summer, how people are changing their everyday decision-making if they live in states with bans, what is our responsibility in this effort moving forward? And how does that change what you do every day? And that is what I think the rest of the panel is really looking at. And I hope that that's what you think about as you go forward, as you've heard how we got to this moment, what the impact is, and how do we go forward. And I'm really going to end with a cheesy line, but that maybe we don't ask so much about stare decisis, but instead we lawyer ourselves to a new North Star. So with that, I'm going to turn. Kristi, did you want to go back or me introduce the next person?
Yes, thank you so much, Leila. And I really love that idea of turning to the North Star and looking forward. I am delighted to now bring District Attorney Sherry Boston here for her remarks.
Good afternoon. It really is a pleasure to be here, and I appreciate being on this panel. And I really want to thank Leila for framing the conversation, because I think it's really important. But I come to you today as a wife, a mother of 2 daughters, and a prosecutor. And even more than that, an elected prosecutor. As an African-American woman, I represent less than 1% of chief prosecutors in the country. And so I live and operate in a space where it's important to me to make sure that minority voices are uplifted. And so when I think about this issue, on June 24th of 2022, life as we know it changed in this country. And on that day, I categorized it in my public commentary as a dark day. 50 years of well-settled precedent was overturned with the dismantling of Roe v. Wade. Reproductive rights, private healthcare matters were now under attack. And although we'd had this leaked draft opinion just months before that gave us a sneak peek into what might happen, it was still unsettling, disturbing, and tragic news nonetheless. And sadly, we are in only the beginning stages of this fight. So here in the state of Georgia, what we have come to know as the heartbeat law is in effect today. This legislation bans abortion as soon as heartbeat or cardiac activity is detectable, which is usually around 6 weeks into a pregnancy, well before many women even know that they're pregnant. So what happens next? What are the repercussions for women, their providers, and those that assist them with seeking abortion care? This new law seeks to criminalize that. But as district attorney, I do not. Whether in Georgia or beyond our state lines, I firmly believe that law enforcement and prosecutors should not be thrust into this healthcare space. And to that end, I have made a commitment not to prosecute individuals pursuant to this law in Georgia. I believe it's a woman's right to choose to make decisions regarding her own body and medical care, including obtaining an abortion, if that's the best option that best suits her. And I have decided that I will use my prosecutorial discretion to implore our resources to combat crimes that actually impact public safety, not private healthcare matters such as abortion. And I believe it is my duty to proceed with prosecutions that are in the best interest of the community for which I was elected to serve. And this has become a flashpoint in the debate and argument as I look at the role that I've been asked to play in this fight. We're seeing prosecutors across the country who have stood up and said that this is not in the best interest of the public safety for their communities be attacked and potentially punished. We saw that with my good friend, Andrew Warren, state's attorney in Tampa, Florida, when he was removed simply for stating, having never received a case in his office, that he did not believe this was a good use of his resources. And he's been removed from office and is fighting that fight right now in Florida. But that's just the beginning, because we expect many more state legislators, attorney generals, and/or governors to try to do the same for any district attorney that dare stand up and take the positions that we have taken. I believe that criminalizing abortion undermines public safety and public trust. And I took an oath to make sure that I maintained the public trust. It's what we do every day when we fight for victims of crime and we fight to hold accountable, violent offenders accountable. And when we don't have trust, it threatens the lives, health, and well-being of marginalized individuals whose access to safe abortions will be restricted greater than others, particularly those in Black and Brown communities. And this is an important issue that we have to talk about when we talk about these criminalization laws. We know it's been in the history of our criminal statutes that there are certain crimes that have disproportionately affected members of Brown and Black communities and those living on the margins. And now, in the face of Roe falling, we perhaps are in, not perhaps, but we are in a position that these laws can be used in a way that we will see members of those marginalized communities prosecuted in larger droves than those that are not. And what we know is that certainly is that overturning the right to abortions will not stop abortions. I worry today for victims and survivors who most need access to safe healthcare options or criminal justice resources following a devastating assault. I fear that they will retreat into the shadows amid their own fears of prosecution. I fear that they will be afraid to come forward and seek the help that they need for fear that they end up in harm's way. But as I stand before you where there is fear, I pray there's also hope and a glimmer of light. We are the light in the midst of this darkness. Light is prosecutorial discretion. I believe that district attorneys and elected prosecutors can firmly stand in the gap and protect citizens. It's not lost on me that the case of Roe versus Wade, Mr. Wade was the elected prosecutor in Texas. He made the decision to prosecute a woman for having an abortion, which led to the Supreme Court making its ultimate decision and giving us that constitutional right. And just as these criminal cases become flashpoints for our rights, I fully believe that elected prosecutors can use that same power and ability to stand in the gap and stand up for what they believe is right for their communities. Light is also challenging laws and notions that seek to take us backwards instead of propelling us forward. Light is a respect for a woman's right to choose. And may the light that we all represent here today offer a small measure of comfort to those who need it most as we fight the good fight in the midst of the darkness that hovers. Thank you.
Thank you so much, District Attorney Boston, for those remarks and the idea of using the power of the elected office to help bring us toward that light. We appreciate your remarks. Next, delighted to introduce Caitlin Chin.
Hi, thank you so much. I'm Caitlin. I'm a fellow at CSAS, which is a public policy think tank here in DC, where I research privacy, surveillance, and technology policy. And I'd like to offer a few thoughts about why data privacy protections become even more urgent after Dobbs. First and foremost, I want to start by recognizing that the decision to become pregnant or not is one of the most personal choices that somebody can make. And it should be a private decision between a person and their medical provider only. Unfortunately, the Dobbs decision completely disregards not only a person's right to privacy from the government, but from businesses as well. The problem is that in the past 50 years since Roe v. Wade was decided, technology has significantly advanced. And now commercial surveillance is extremely prevalent in our society. These days, and especially after and during the pandemic, we perform so many of our daily activities online. And the many websites, apps, and internet-connected devices that we use every day collect massive amounts of information from us, including information that could reveal a person's reproductive health status, such as what locations we go to and when, what websites we visit, what we shop for online or what we browse for, who we communicate with and what we say, and so much more. In turn, many of these details could either directly reveal or be used to infer sensitive information related to our health or pregnancy status. And worse, companies could potentially store this information for very long periods of time or share it with other companies, with advertisers, with data brokers, or even other individuals or government agencies. The privacy legal system in the United States is very fragmented. It has not been updated on a national level to keep up with technology, and as a result, many smartphone apps and websites face few legal rules on how they collect information, how long they store it for, and who they share it with. This manner of under-regulation has essentially allowed companies to build extremely profitable business models around offering free or low-cost products and services like apps and share them with countless third parties, including data brokers, businesses that combine or aggregate information from multiple sources to create massive data sets. As just one example, the FTC has recently filed a lawsuit against a data broker called Kochava, which has packaged and sold geolocation information from hundreds of millions of devices. And some of the mobile apps that Kochava has packaged information from include period tracking apps. This information includes unique identifiers that can identify specific mobile devices with timestamps that reveal location history as well, and could be used to identify people who potentially visit abortion clinics. And I want to know that Kochava is only one company. Since the data broker industry is a black box for so many people, the public is often unaware of which companies and how many have access to their personal information. What we do know is that data brokers have in the past and are continuing to infer whether somebody is pregnant and target advertisements for pregnancy or baby products. And what's more, we do know that many data brokers, for example, Ventel, Xmode, and Babel Street, have either in the past or currently entered into contracts with law enforcement agencies to voluntarily sell information without the use of a warrant, subpoena, or court order. But again, there is very little transparency into data broker contracts in general, so the public does not always know the full extent of this problem. So when the draft Dobbs decision was leaked in May, my immediate thought was that years of commercial surveillance, data sharing, and lack of privacy protections has created this massive treasure trove for anti-abortion law enforcers, organizations, or even individuals to target those who either choose to or might consider an abortion in violation of their privacy. So I'm really glad that Georgetown has created this space for us to talk about these topics. It's scary to think that the same information that is used to infer whether somebody is pregnant in order to target advertisements could also be used as digital evidence for a law enforcer to investigate or prosecute an abortion, or that malicious actors such as domestic abusers or anti-abortion groups could potentially obtain this information in violation of somebody's privacy. That is why the United States needs nationwide boundaries on how all private companies collect sensitive personal information and share it with others. And that has been the focus of my career. Currently, there are just too many gaps in the system, but companies need a legal responsibility to prevent harm to individuals. At the bare minimum, businesses should only be allowed to collect personal information that is necessary to provide the product or service that somebody specifically requests. And they should delete and stop retaining data after it's no longer necessary for that purpose. And they should not profit from data that could be used to identify or infer intimate details such as reproductive decisions, relationships, and more. And what's more, we need meaningful transparency to hold both companies and government entities publicly accountable for data collection and sharing. And just one last thought, over the past few months, many of my friends have reached out to me to ask how they can protect their health data after Dobbs. But the problem is, without federal abortion protections and without federal privacy protections, there is a limit to what individuals can fully do to protect ourselves. We can take small actions like deleting period tracking apps or avoid texting or emailing about abortions, but we can't opt out of using the internet altogether. Just like District Attorney Boston just mentioned, I also worry that Dobbs could create a chilling effect where people are very understandably scared to search for information about reproductive health online, as one example, and ultimately potentially cut themselves off from important health information that they need. Ultimately, it's very hard to participate in society in 2022 without leaving digital evidence. That is why, more than ever, we need stronger data privacy legal protections. Our panel is titled The Future of Dobbs, Opportunities, Activism, and Creative Rage. And when it comes to opportunities for creative activism, the first best thing is for advocates to push for federal abortion protections. But if that is less feasible in the current political climate, then I'd like to say that the second best thing we can do is advocate for stronger privacy protections, both from private companies and from the government.
Thank you so much, Caitlin. I learned a lot, and thinking about that need for data privacy and federal data privacy regulation is so critical. Thank you so much for your comments. Now we'll turn to Victoria Nourse.
Hi, can you all hear me?
Yes.
All right, thanks. I'm just finished a lecture here at the University of Cincinnati Law School, and all dressed up with pearls and everything. It's Constitution Day. And I'm delighted to be on this panel because I have practiced in my other life working in the Senate, White House, other forms of law, namely legal action, policy action. And I think that's a very important piece of the puzzle moving forward. And at all levels, I was delighted to hear from the district attorney and from Leila and also from folks over at CSIS about their policy initiatives. And I don't mean to take up a lot of your time, but I will give you a few things that I believe that I've learned in my time working on anti-sexual violence and my work on the Violence Against Women Act that I think might be able to help. So they're not traditional legal remedies. As far as the traditional legal remedies, obviously we have potential federal legislation. I'm a bit worried about how it's drafted now, but it can't pass, as far as I know. So what's the next thing? Guess what? We all can vote. The Constitution is a dynamic system. And so when the court, and it has done this over, its errors with Dred Scott, Lochner, the response to Brown in a highly salient case, we all know that the people who find the court's rulings offensive will push back. Now, you can push back in the courts, in the state courts. There have been a number of activities on the state level. So for example, there was the Kansas move where folks pushed back against and I believe it was an amendment to the Constitution, but it was a referendum. And now Michigan has abortion on the ballot. So there's a lot of activity that can happen. This is what I consider to be constitutional activity. Every time we vote, we act constitutionally, and can be much more important in some ways than arguing a case in front of the Supreme Court, which is only part of our Constitution. So there can be arguments in the state courts, but there can be public action in the states as well to enshrine a right of privacy. Many state constitutions have a right to privacy and enforce them. Direct action on the ground, refusing to prosecute, as we heard earlier, is a really important piece of this, resistance. But also informational campaigns are essential. And that's what I want to emphasize. When I worked on, so many years ago, the 1994 Violence Against Women Act, one of the things that we were doing was trying to convince people that something that they didn't want to believe happened. It was a day and age in which people on the floor of the Senate, and there were only 2 women senators, would say that battered women's shelters were akin to feminist indoctrination camps. It was a long time ago and things have changed. But one of the key things in any public policy movement is information. Now, there are dangers of information, as we just heard from that very interesting talk from Caitlin from CSIS. But there's also power in information. There's a massive amount of information that I think the Supreme Court had no clue about when it decided this case. Obviously, there are medical information. And so lawyers and doctors need to get together to try to improve people's understanding of the difficulties. And we've seen the newspapers detail things like ectopic pregnancies and other kinds of ailments of children who are not going to be born live, and all the various reasons why abortion actually is healthcare. But that information needs to seep down and be locally available and discussed ad nauseum. People think, for example, that a heartbeat bill means there is a heart. There is no heart. That heartbeat is coming from the ultrasound machine. So there is massive amounts of scientific misinformation that's going on. But there's also misinformation about the violence that this perpetrates on women. And one of the truly terrifying things for me, hearing about this and having tried to actually and failed, and it's still working on issues involving violence, is the degree to which people are willing to force individuals who have been violated, who have been raped, to actually carry to term children. So one of my suggestions for all advocates is to get out of Washington and go to the states where this is happening and have legal students be in the hospitals and have a national repository of information about the people who are going to suffer, who are going to die, who are going to have to live lives they did not want to live. And there will be people. Why do I think this mattered? One year I wrote a report called 1 Week in the Life of America. And it detailed the horror stories of the endurance of women in the mid 1990s, early 1990s, mid 1990s. It still goes on, but the attitudes have changed enormously and the information mattered. It seems like a banal topic, but sometimes when you're fighting misinformation, the only thing you can do is to collect it. So if there were a national repository of information regarding things like women who were delayed treatment, who were forced to flee to another state. I heard a horror story from a woman on the floor of the South Carolina legislature talking about a 10-year-old girl who was raped by her brother and had to carry the pregnancy to term at some point. These stories are there. They're not reported in the newspaper. And so activists, I had the help of shelters, people on the ground. Activists need to get these stories together. Those stories need to be briefed in the courts. They need to be sent to legislatures. And if put together, they will paint a very powerful picture of how this society has never acknowledged injuries to women. I mean, the Supreme Court has done a terrible job since 2000 on these issues, and it continues to add insult to injury. And the final thing I want to say, those are very practical solutions. And I think law schools can do this, advocacy organizations can do this, and teaming up with doctors who also have a personal interest in not being thrown into jail is always helpful. But I also think it's exceedingly important for y'all to realize what I just said in my Constitution Day lecture, which is I testified for the ERA about 6 months before Dobbs came down. And I did that because I'm in Washington, I live across the street and whatever, and also because of sexual violence, I didn't really talk about abortion at all. But I got thrown into a press conference at one point and I wasn't really prepared. But I study how the court interprets law. And so I was thrown into this clatter and I said to them, and this is before Dobbs, before I knew what was going to happen. And I said, be afraid. Because the Constitution is going to change because we have a very new and radical court in town. So when you read Dobbs, be afraid. It's not just, and I think this is something to say to people who may have a different view about abortion in terms of morality or religion. That opinion takes us all back to 1868. And for every person of color, everyone who loves a woman, female, it is an atrocity. So I have an alliance now to fight originalism, which is what I do. So anyone who wants to join that, you can come on board. It's a stupid idea and the court will rule one day. And that's inside the courts. But most effective advocacy, and what I tell my daughter's generation, is to build the case, get the evidence, talk to people who you don't really understand, have never thought about it. So thank you for listening and thank you for being on this webinar. We need everyone.
Thank you, Victoria. I'll echo that. We need everyone. And as someone who works at the Cancer Center, I can wholeheartedly concur that abortion is healthcare. We hear that among some of our cancer patients who are making these life and death decisions on moving forward. And the thought of moving back to 1868 is shockingly chilling. And so using our voices to move things forward and gathering evidence. Thank you so much. I'm now delighted to turn it over to Liz Reiner Platt. Liz?
Hi, thanks. Can you see my slides and hear me okay?
Yes.
Wonderful. So thank you so much. For those of you who are new to my organization, the Law, Rights, and Religion Project, we are a law and policy shop that promotes religious liberty and pluralism, and we do quite a lot of work at the intersection of faith and reproductive health. First, absolutely acknowledging all the very real limits of the law that Leila laid out in her wonderful opening comments. I was asked to speak about lawsuits filed both before and after Dobbs, which argue that the right to religious liberty under US law includes a right to receive, perform, or facilitate abortion care. We just released a whole report on this for those who are interested, and I will drop that in the chat after my talk. But before diving into the law, I just wanted to take a moment and lay out that there is a very long and rich history of religious participation in the reproductive health rights and justice movements that I think is finally getting more recognition after years of the Christian right really dominating the conversation around faith and abortion. Many religious denominations support abortion access in all or most circumstances. Several have actually come out and said that abortion access is an essential part of their members' religious freedom. Many abortion providers have described their work as religiously motivated, and as some of you may know, in the days before Roe, clergy members nationwide formed a group called the Clergy Consultation Service on Abortion to refer people to safe abortion providers, and groups like Sacred Dignity, Religious Coalition for Reproductive Choice, and many others have really kept that legacy going today. So this idea that's really taken off in news articles and other places that religious freedom includes a right to make reproductive decisions based on one's religion or conscience is not something that lawyers kind of cooked up yesterday in response to Dobbs. It's a narrative that's very long and that has been, I would say, primarily driven by faith leaders and faith communities themselves. So that said, what do these legal claims actually look like? Well, there are many religious liberty protections that might come into play in a suit challenging an abortion law. Over the past 50 or so years, there have been cases arguing that various abortion bans or restrictions violate the free exercise clause of the US Constitution, which protects people's ability to practice their religion and in at least some circumstances might provide someone with a legal right to violate a law that conflicts with their religious beliefs and practices, also known as a religious exemption. There have been cases involving the Establishment Clause of the US Constitution, which prohibits the government from adopting or promoting religion, aka church-state separation, or what's left of it after this year. There have been cases brought relying on state constitutional protections for religious liberty and on state versions of a federal law called the Religious Freedom Restoration Act, or RFRA, which grants an extremely broad right to religious exemptions from the law. I'll note that the Federal Religious Freedom Restoration Act is typically less relevant because it only provides exemptions from federal laws and policies, so it could not be used to gain an exemption from, let's say, a state abortion ban. All right, so what does the case law say? Well, while there have been quite a number of lawsuits filed making these cases, very few of them have resulted in a full opinion. So we actually don't have a whole lot of guidance here. For time's sake, I am not going to go into too much detail. Those who are interested, there is a really detailed case index in that report I mentioned earlier. But really the biggest case to flag is Harris v. McCrae, which landed in the Supreme Court in 1980. This was a challenge to the federal Hyde Amendment, which of course still exists and prohibits almost all federal funding of abortion. Advocates in the case argued that the funding ban violated the free exercise clause of the Constitution because some women are religiously motivated to seek abortion care. And a federal district court judge in New York actually agreed and found that the Hyde Amendment in some cases violated the right to religious liberty. The Supreme Court later overturned this free exercise ruling, but only on procedural standing grounds. So we did not get a substantive answer from the court on that free exercise question. Harris v. McCrae also included a challenge to the Hyde Amendment based on the Establishment Clause, arguing that it essentially incorporated Roman Catholic doctrine into US law in violation of church-state separation. And this argument was explicitly rejected on the merits by the court, which said that just because a law may overlap with certain religious beliefs, that doesn't make it a religious law. And since then, there have been a handful of other challenges to abortion laws based on the Federal Establishment Clause that have also typically been rejected. That said, I'll just note that a challenge based on a state constitutional Establishment Clause language, or perhaps a challenge to a law that more explicitly references religion, which we're seeing now, could potentially meet with greater success. Pre-Roe, there were a few cases brought by members of the Clergy Consultation Service that I mentioned earlier, arguing that they had a religious liberty right to counsel people about abortion decisions. None of those cases got the chance to be fully litigated. And the Satanic Temple has brought lawsuits in Missouri and Texas, arguing that its members' religious belief, including a belief in bodily autonomy, are burdened by laws imposing various restrictions on abortion. The two Missouri suits were both dismissed and the Texas case is ongoing. And there have also been religious challenges to state fetal burial laws. Since the Dobbs decision, we've also seen a bunch of new relevant cases. In EMW Women's Surgical Center v. Cameron, a Kentucky State Circuit Court judge issued a decision that sua sponte found that two state laws banning abortion violated religious liberty protections of the Kentucky Constitution. And sua sponte means that the court ruled on this religion question without it actually having been raised as an argument by either party, which is very unusual. State court judges in both Utah and Wyoming have paused abortion bans in those states, in part because they thought religious liberty arguments raised by the challengers, among other arguments, had some merit and needed to be fully heard. The ACLU of Indiana just last week filed a complaint on behalf of patients with religious reasons for seeking abortion care. Several cases have been brought by faith leaders challenging Florida's 15-week abortion ban. And last week, there was a letter sent to Texas AG Ken Paxton on behalf of Methodist ministers in the state challenging the state abortion law. And that's the first step in filing a lawsuit. So in summary, the idea of demanding a religious liberty right to access, provide, or facilitate abortion care is far from unprecedented, but we really don't have a lot of direct court opinions on the issue, at least when it comes to religious exemptions. So I could go on all day about the details of how these cases could be framed, how they could potentially play out. I have to wrap up, but suffice it to say that religion law is a really, really complicated and really dynamic and rapidly changing area of the law. I think there are a lot of strategic considerations in these suits. I think there are meaningful risks in these suits. So, if folks have more questions or really want to think about this more, I'd really encourage you to take a look at the memo and please feel free to reach out to me. Thanks so much.
Thank you, Liz. Really appreciate walking through and then hearing the particular examples from the different states. Very, very helpful. Now we are ready to hear from Anna Rupani.
Hi, y'all. My name is Anna Rupani. I'm the Executive Director of Fund Texas Choice, and I use she, her pronouns. I thank you everyone for who's spoken about what's been happening on the ground post Dobbs and what this could have led up to. I'm here today because Fund Texas Choice is an organization that is based in Texas and responded to the needs of what happened post SB 8, which was better known as the Heartbeat Bill in Texas, and the Bounty Hunter Law. And I apologize ahead of time. I am not going to be on camera. I am dealing with a broken ankle and a torn ACL, so I am kind of splayed up on my bed. But Fund Texas Choice, and to understand kind of what happened post SB 8 with the Bounty Hunter Law, I'm going to give you a background of what Fund Texas Choice does. Fund Texas Choice was founded in 2013 in response to House Bill 2, another anti-abortion law that was passed in Texas that required clinicians to have admitting privileges in hospitals nearby. What that did when it was enacted on November 1st, 2013, meant that 50% of clinics shut down overnight. And by the time 2014 rolled out, the entire state of Texas had 8 clinics only. And so think about the population of folks in Texas that get abortions. It's about 60,000 people, and they had only 8 clinics that they could go to. That meant folks had to travel further for appointments and probably travel out of state. And so Fund Texas Choice was founded in response to that need. What we do is provide practical support. We provide travel assistance, lodging, food assistance, gas assistance, childcare, kind of all of the in-between costs that one might incur from booking their appointment to getting to their appointment and then coming back home. And so when SB 8 was passed and then enacted on September 1st, that really impacted our organization and to other organizations like ours that are not just practical support funds, but abortion funds, folks that fund the procedure themselves. Prior to September 1st of last year, 30-ish% of Fund Texas Choice's clients were leaving the state to access care. And as soon as September 1st hit, 99% of our clients had to leave the state to access care. And so that in terms of just raw dollar numbers, we went from spending close to $100,000 on practical support to last year, since SB 8, we spent $625,000 on providing practical support to folks leaving the state. Why that matters now is states like Texas, who don't have access to abortion care, all of that is amplified, not just in Texas, but all of these other states. So all of these other states are having to incur the costs, and these nonprofits and abortion funds are having to incur those extra costs that are amplified by 6, 7, 10 times more than they used to be. When I talk about raw numbers as well, prior to September 1st, when folks were allowed to travel within the state, we received maybe 40 calls a month from folks seeking care from us to get out of state or needing help to get travel to their appointment within the state of Texas. Immediately past September 1, we started receiving 300 calls a month. So the volume was 7 times more than what we were expecting. We doubled our programmatic staff size, and we still couldn't keep up with the demand. The longest one-way trip someone had to travel from Texas for our organization was 2,164 miles. That means people are traveling from Texas all the way to Washington or to Maine or to New York. And that's pretty significant because Texas is a large state. And so when you have more states doing that, it's going to burden the states on the outset that where abortion is protected. It is a domino effect. And as we know, what happens in Texas doesn't stay in Texas. And so we've seen this play out pre-Dobbs with other laws that were passed like SB, and then post-Dobbs where folks are trying to ban abortion outright. Or as you heard yesterday, if you haven't heard, the Alabama AG yesterday came out and said that they are going to look to prosecute folks that are in fact helping people leave the state or who are assisting people to leave the state to access abortion. So it comes to today, where are we here now in September, a year later, and what are we doing to resist this impossible situation? Unfortunately, post-Dobbs, we had to pause our services in order to understand what that meant for us legally. We as an organization have received several cease and desists and threats from legislators and other attorneys and other antis saying that if we continue to do what we're doing, we are going to in fact be violating what are known as the pre-Roe statutes. So statutes that existed in Texas banning abortion prior to Roe and somehow have been resurrected according to these litigators and legislators now that Roe has been overturned. And because a lot of them don't actually have statute of limitations and they haven't been tested in the courts, we don't actually know whether or not a court would say they're valid or not. And the only way to really test them is to in fact force someone to be arrested. And that is actually real harm for a lot of the individuals that work at abortion funds and practical support funds that are made up of predominantly Black, Indigenous, and other persons of color. And as we know, the carceral systems are not favorable to Black, Indigenous, and other persons of color. And so that does require actual and physical harm that might happen to our staff members that we had to, we did not want to happen. So we made the decision to pause our services. In the meantime, trying to resist this impossible situation, Fund Texas Choice, along with 7 other abortion and practical support funds in the state of Texas, has filed a proactive lawsuit against Ken Paxton and the other AGs in the state of Texas and the other DAs in the state of Texas, saying that the pre-Roe statutes, the trigger ban and the trigger ban violate not just the First Amendment and the 14th Amendment and the Fifth Amendment, but also the Commerce Clause. And as Elizabeth mentioned, we don't have clarity on some of these areas of law, so we have to test them to get clear answers. I know when I went to law school and I was a practicing lawyer for 10 years before I took this role, I remember my 1L year and learning about the Dormant Commerce Clause and the Privileges and Immunities Clause, never thinking that I would be here in 2022 arguing in front of the courts that travel isn't a protected right. But here we are because we aren't in fact sure when AGs of other states and conservative states and states that are trying to restrict abortion access are saying that that's an extraterritorial jurisdiction is allowed. So we are trying to fight against that issue. And so Fund Texas Choice is the lead plaintiff because we are the only statewide practical support organization trying to get Texans out of state. We are also working with our local municipalities and county DAs who, like Attorney Boston, refuse to prosecute individuals helping pregnant people obtain abortions. And we're trying to get that in writing, and we're trying to make sure that it's not just based on prosecutorial discretion, because if, say, Attorney Boston isn't there next term, then we don't want to be with another district attorney that might decide the opposite way. And so we're trying to pass things like the Grace Act and give power back to cities where they know at least that their neighbors have their back, that their neighbors are going to fight for abortion access. And we have our hearing for our actual case, Fund Texas Choice versus Paxton, on September 27th for a preliminary injunction on these very issues, and hoping the court will side with us in saying travel is a protected right. Texas can't, in fact, go beyond its borders and say that folks in Texas that are helping Texans seek care in states where abortion is legal can be in trouble for violating many of the anti-abortion statutes that are kind of on the books now. So it does take a lot, and it does mean that many people have to come together to make this happen. But we're hopeful for this hearing on September 27th, and we're hopeful that folks will be able to have more relief as time goes on, because the law is important. And it's been hard for me as a lawyer in my past life to see how the Supreme Court responded to Roe and how the Dobbs decision was written out, because it does feel like at some time, it does feel overwhelming that the law isn't on our side, but we know it is. And that is why we're willing to go back to the courts to make sure that they can either say, nope, you can't travel out of state to do whatever you want to do, or actively say you can travel out of state and what happens in Louisiana doesn't impact Texas and so forth. So that's, I'm gonna go ahead and say that I'm good, and this is where I'm gonna stop so we can leave more room for questions.
Thank you so much, Anna, for your work and advocacy. And I'm really moved now to invite the panelists, as they feel comfortable, to turn their cameras back on and respond or react or ask questions to one another first before we open it up. We do have a number of questions in the chat that I will then read after, but I invite the panelists for any additional remarks, comments, or questions. There was some overlap, I thought, between the idea of the repository that Victoria mentioned, and then thinking about some of Caitlin's remarks with data privacy. And then in the Q&A, there was a question about, how do we mobilize to do this? And that some of, in particular, perhaps some of the medical organizations might have some concerns, and Victoria responded in there. But I would love Victoria and Caitlin's thoughts on those ideas about a national repository and how we might move forward with something like that, as well as then later attention to some of the potential privacy concerns.
Well, first, bravo to Anna with their torn ACL and to taking this. I mean, I never thought that, I'm sure I'm a lot older than you, that someone would actually have to litigate the right to travel. If you need any law professors, I'm sure I can get about 200 on a letter if you need them. Don't ask until I get back to DC, but in any event, bravo, and I'm sorry that you have to do this, just for providing help. So good luck. So on the repository, it doesn't have to be any, it can be a loose coalition of organizations, like there's a loose coalition of domestic violence organizations in the United States. And it can, I understand the fear of confidentiality. In my experience, of course, I had the same fear, because these are people who are at the time victims of husbands who are continuing to stalk them, and or their partners, and as well as survivors of sexual assault. So it can be anonymized. I mean, what you really want to do is have a checklist. This is what I said I replied personally to the individual, but I said, you really want a checklist of things, harms that everybody on this call can imagine, but that need to be documented. Let's just say, I mean, having had a DNC myself, if I had to wait a week and was bleeding, I mean, these kinds of things can be identified as, delay in treatment, how long. It can be anonymized. If you have the participation, obviously, of the doctors, and that's problematic. I know they're busy, they don't want to spend time, but in fact, women's advocacy groups could station people. There are apparently hospitals who are hiring lawyers to be in the emergency rooms. They have an interest as well in not getting their doctors afraid, etc. So there's got to be some way to provide an anonymized system of data without even identifying the state. You could collect it all together by people who would just, either be stationed or call the individual doctors. It would be anonymized, but you'd have to have their or the patient's cooperation, obviously. Now, it doesn't have to be as sophisticated as you know, a super sociological study. When I did my work, it was often not, it wouldn't meet the standards of academia. But it can be, I did 1 week and it was overwhelming. And these were anecdotes, but the collectivity of the information, the weight of it is not that it is super statistically, you know, coordinated, but that it's not just a one-off story in your local newspaper. And that's what's happening, because the national press is not going to report the 3-week delay. And that's going to happen everywhere. And it's not going to report how many people have traveled across states, how many people have, you know, had even much more serious problems, how many people, as I think Kristi or someone said, are in a cancer ward, you know, and have to make these decisions. I do think it's possible. I think it's difficult, but it can be anonymized and it can focus on relatively objective factors. It can even be reduced to a checklist. You need a lot of volunteer help, but you know, I don't know. I remember my daughter calling me up saying, "Mommy, can they do this?" I was saying, "Yeah, they can do this." And having not a political bone in her body, she was ready to go do something. So I think there are a lot of people who might be ready to volunteer to do these kinds of things in the number of states we're talking about.
Thank you so much, Victoria. Yes, please.
I think Victoria touched upon something that's very important, which is that it's possible to reduce the amount of information that's being collected. As a principle, data minimization is paramount to privacy, both in terms of only collecting information that's strictly necessary and also deleting, when possible, information that's no longer necessary, just to reduce the amount of information that's being stored, to minimize the number of people who have access to this information, but then also reduce exposure in case law enforcement wishes to access this information as well.
Thank you so much, Caitlin. Liz?
Yeah, I just wanted to briefly throw on there that we also might not be starting from absolute like zero from scratch, in that there has been a lot of study of honestly very similar stories and experiences at hospitals that pre-Dobbs had extremely strict limitations on abortion care, particularly the experience at religious hospitals. And so there's been a lot of story collection there, a lot of work by many organizations on Catholic hospitals. To toot my horn, last year we did a big report on abortion bans at a range of Protestant hospitals, focusing on the South, that included a storytelling component. So that might be another kind of just history and body of work to draw on as we think about what that story collection might look like.
Thanks so much, Liz. Yes, that idea of the individual story as moving, but also the collective weight of many, many, many stories. Yeah, thank you. Leila.
Yeah, I just to provide just a quick thing that kind of touched on in my remarks about social media. And we all know how harassment can be really terrible online. And it is very terrible for anybody usually who speaks out about in support of abortion. And so just to have that weighing in on the conversation of protections and things people can do, which I'm sure Caitlin also thinks a lot about. So just again, this brave new world that we're in, that is not the pre-Roe, that is what it's like, that a lot of our life is online. And then more broadly, storytelling is really key to the work that we do. And there are groups who are very committed to, and this is what Liz said, to supporting storytellers and capturing the stories. And so, you know, there's a lot of intentionality that goes on there because of both making sure the person is protected and feels safe, and that we move forward in a way that is protective. And just as a note, that often it's the abortion providers that get in the crosshairs of the attacks, because there can also be the public face. So just thinking about how the story is being told is very careful, and especially now that it's all criminalized in a way that it wasn't before when we did storytelling. So I think that's not totally responsive to the threat of a repository, but just some ongoing, whenever we have like hearings in Congress, what we face afterwards in terms of the attacks and such. So just a couple of notes there.
Well, I don't disagree with that. I mean, so yeah, I mean, many people on this, including myself, have been subject to many, many kinds of attacks, and I really don't, and that may be one worry of the doctors, because they may fear, I once taught criminal law, that they're actually will be outed as aiding and abetting. I mean, so there's an added layer here of difficulty that I hadn't anticipated, but there's got to be a way to do it by locating it maybe in a in some kind of safe place. There are many different kinds of ways to do it. And I know you get backlash. I mean, trust me. And it's not pretty. It's not pretty. But I think that's kind of, what we have to sort of gird ourselves for. And I don't think we should let doctors off the hook. I mean, to tell you the truth, I think they're probably trying to protect themselves and their time. And I'm trying to protect myself and my time too. But if that's the objection, I'm happy to talk to them and talk them out of it. Because it is ultimately a short-termism for them. It won't help unless we know what's going on, in my opinion.
Thank you so much, Victoria. And thanks, Leila, for bringing up that important point about, the different types of considerations as we move forward. Anna, you had your hand up briefly. Anything you would like to add?
No, sorry about that.
Okay. And then just eliciting any final comments or questions among our panelists before we go to the important and dynamic questions that are appearing in the chat.
Well, unfortunately, I am so inspired by you, but I have to leave Cincinnati. So I'm going to run out. It's so nice to meet you all virtually. And if there's anything we can do at Georgetown, I know some fancy lawyers there like Deborah Epstein and Naomi Mezzi and the inimitable, brilliant Robin West. So we are always happy to have you reach out to us and our students. There are many other women on our faculty who don't actually specialize in this, but have asked me what can they do. So there's plenty of energy. And I thank you for the Georgetown Gender Justice Initiative. And I apologize for this rude departure because you people who are all younger than me, you inspire me.
Thank you so much, Victoria. Thank you.
Thanks for coming back.
Bye.
On that note of inspiration and working together, we can turn now to some of the questions in the chat. So we have a question about ideas for what to use as part of an information and education campaign, and that includes the World Health Organization's recommendations that the decriminalization of abortion, as well as the UN Human Rights Committee, that the criminalization of abortion results in women dying and thus violates the woman's right to life or the person's right to life, and then also supported by the International Covenant on Civil and Political Rights, which the US has ratified. So ideas about bringing some of these points, kind of national policy and human rights and health organization elements into the mix as we think about the types of information and education campaigns. Welcome any thoughts from any of our panelists on that one. In the spirit of that multi-dimensional, multi-sector approach that I think we've talked about, law, medicine, policy, data privacy, to me, those ideas make a lot of sense to bring forward the different elements and kind of levels of rights and recognition as we move forward. Any other final thoughts on that piece? Okay. And another question that we have is whether there's any literature on defending abortion based on fetal rights, as in a future child's right to adequate parental care or access to resources, which the parent will not be able to provide, or the potential issues with making an argument around the child's rights as opposed to the pregnant person's bodily anatomy, kind of flipping the lens of the rights. Any thoughts on that from anyone?
I can pop in if others want to add, is that, you know, there isn't, I think, any real development in the law of this framing. So I think the immediate answer is no, but just as to flip it again, is that this is actually the effort of the anti-abortion movement, is to assign personhood to fetuses, and that means that their interests supersede the pregnant person's interests. And so then that gives grounding for a nationwide abortion ban, because the fetus is a person who then you can't terminate. So just a note there about the through line, but I think what your point is getting at is something that we often talk about, is a lot of the anti-abortion movement in focusing so much on banning abortion. Often you hear legislators that oppose those bans that they do nothing for the families once the children are born. And you know, you feel this profoundly in states who have not expanded Medicaid and don't address the root causes of, we know about poverty. I mean, there's data about slashing child poverty over the last couple of years, and how there's been policy has real impact in people's immediate lives. And then you look and see who supports those policies, and whether or not there's this support for supporting all the way through the life. So I think that there is a bigger point of, how does our country approach supporting people in their lives all the way through? In the National Law Center, like, nice working there, because I get to hear about my colleagues and the fights that they're fighting for, including the Pregnant Workers Fairness Act, you know, just protecting pregnant workers, and that our country actually fails in so many ways to support women and families. And so it's more naming how we as a country just fail women all along the way.
Thank you so much, Leila. Yeah, that idea of the just lack of most policies to recognize and uphold some of these rights for women and families.
So I wanted to jump in here because in Georgia, the heartbeat bill, which passed in 2019 and was on hold in appellate courts until Roe fell, and then the 11th Circuit immediately allowed it to go into effect. Besides criminalizing abortion, one of the things that particular bill did do was grant personhood status at 6 weeks to embryos with cardiac activity. And so this has become a flashpoint. And keep in mind, traditionally, when laws are challenged and they are in federal courts, generally speaking, when the appellate court sends back down the status of a decision, generally speaking, there's 28 days to allow preparation time for affected parties and agencies to be able to prepare for any changes or ramifications as a result of the law. That did not happen here. So just as we received the decision for Roe v. Wade, kind of mid-morning, effective immediately, we also, when Georgia's heartbeat bill was upheld by the 11th Circuit, it was sent down and immediately gone into effect. And so as we are addressing this personhood status, our law specifically says that women can seek child support as early as 6 weeks. with the personhood status. Citizen parents in Georgia can get tax credits in the same year as a pregnancy immediately at 6 weeks, whereas before tax credits came, as you know, after the birth of a living child. And then finally is the larger question in my role, which is we have very strong aiding and abetting, as well as attempt laws here in the state of Georgia. So in the state of Georgia, if you are charged, one person can be charged with murder and another person can be charged under the aiding and abetting statute, and the penalties are equally the same. So if you are charged as aiding and abetting, or also known as party to a crime, you face the same punishment. So one of the challenges here that we're facing, and many of the legislators that supported this bill said, oh, it's not our intent to criminalize women. It's not our intent to criminalize people who assist. We just don't want doctors performing abortions. And we know that the consequences of the law by giving this personhood status simply makes it right now that if a prosecutor were to bring an indictment against someone for helping assist in the termination of a pregnancy, whether that's the mother, the doctor, the person that drove her to the doctor's appointment, that knew about it, that helped her devise a plan, all of those people ultimately, and it's my position, by the wrong prosecutor, could all be charged with murder. Because if a fetus has personhood status, the death of a person in Georgia is murder. And that carries a mandatory life sentence in the state of Georgia. And if you're charged with party to a crime, you too would face the same exact sentencing. So it is a real concern. And I think we're going to see a lot of litigation happen in Georgia. I mean, particularly when I talk to my family law friends, you know, we all know that the first thing you have to do to get child support is establish paternity, right? That's a part of it. How are we going to establish paternity on fetuses at 6 weeks to enforce child support laws at that early stage by making this personhood argument? So I believe on the ground here in Georgia, we're going to see criminal and civil litigation around the idea of personhood status that currently, as of right now, is the law in Georgia, subject to the challenges that are going on in the courts right now. But our law has not been stayed. There is no current temporary stay order, so it is currently in effect as we speak.
Thank you so much, District Attorney Boston. Naomi, did you have a comment you wanted to add?
Just very briefly on the question of the literature on this, I do think we want to be really careful about using the language of fetal personhood to make this argument. As others have said, that's a dangerous game, and it's ironic that so many of the people who make access to abortion so difficult have also make very little, support very little in terms of what to do with children who are then born and need the resources of the state. The piece of literature that really I thought about with response to this question is by Megan Boone. It's called Reproductive Due Process. And it's a really interesting thought piece about if the state has the ability to conscript women's bodies in order to protect the rights of a fetus, then what does the state then owe for that claim and that time that it essentially requires women to carry the fetus and then protect and raise the child? And so she sort of spins out this thought experiment, and it's a really interesting piece that suggests maybe, in fact, what the state owes in response to that is forms of child support, early childhood education, aid when the parent needs aid, all kinds of things. And it's there's aspects of it which are fanciful, but in the world in which we live right now, I think everything fanciful should be on the table in order for us to be able to think really broadly about what that sort of future should look like, to make it as inclusive and as sort of visionary as possible.
Thank you so much, Naomi. And before we wrap, we'll turn back to ideas for vision and moving forward. Anna, you had indicated that you might be able to answer the question about speaking to how these laws also affect immigrants and refugees and asylum seekers in the US.
Yeah, so I don't have a happy response for this, and I apologize. It's not one that I obviously can take ownership of, but living in Texas and having been an immigration attorney in Texas, a border hotspot. When SB 8, for example, went into effect, undocumented immigrants across the border were pretty much unable to access care or services because as most people have learned over the course of the last couple of years, there is that 100-mile distance from the border that Customs and Border Patrol or any law enforcement officer can ask you to show your documentation. And so for undocumented immigrants especially, what ended up happening is they can't really leave that border area. For other immigrants and refugees and asylees, although they may have documentation to travel, the reality is traveling is really hard for folks that are in restricted states, especially because that requires documentation. And they may have documentation, but they may not have they may have never flown on a plane, or they may not speak English, or English may not be their preferred language, or they may need a companion to go with them to help them navigate these barriers. All of those things are very expensive, and all of those things aren't always easily affordable. And so the immigrant population is actually one of the populations that has been significantly impacted by these anti-abortion laws because there's access to language, there's access to documentation, and then there's also that fear of leaving your safe zone and being in touch with TSA, Customs Border Patrol, any of those individuals that you might have to interact with in terms of traveling. So for immigrants, the question really boils down to, do they have some kind of documentation to be in the United States, or do they not? And if they don't, the answer is unfortunately very grim for them to access care. On the flip side, a lot of folks at the border and in other areas where undocumented immigrants live, they have been able to access they've contacted organizations like Aid Access and Plan C, where they've been able to access resources to potentially have an SMA at home. But that also implicates other legalities that folks have to pay attention to. Where, say, an example in Texas, SB 4 is existence, and having access to those pills could lead you up for criminal liability. And so there are layers, but unfortunately, the answer for undocumented immigrants is not great. And then for immigrants who have documentation, it just depends what access and resources they may need to get to care, especially if English isn't their preferred language.
Thank you, Anna, for highlighting all of those really big challenges that people are facing. And Liz Reiner Platt has a question in the chat that she's going to answer live.
Yeah, sure. There was a question about the role of international law and particularly a ruling by Columbia Supreme Court in terms of religious liberty challenges, and whether I've seen kind of international law references or arguments made in any of the cases I mentioned. I have not, but maybe it's worth going back and just looking at the papers and seeing if there's anything buried in there. I'll say briefly, U.S. courts are not known to be particularly receptive or interested in international law arguments. So that can be a challenge. But I guess in the interest of having a more interesting argument than just no, I'll say it might be kind of interesting, less as a legal argument, but more as kind of a movement argument to think about a tactic of another faith-based movement, which is the immigration sanctuary movement, that incorporated kind of international law arguments in sort of an interesting way, essentially arguing that their activity, like the kind of argument they made is humanitarian aid is never a crime. We are actually working to enforce in our activities. Helping bring refugees into the United States is actually helping to enforce international law, which has been ratified. And it's actually the government, and specifically the Reagan administration, that is in violation of the law. So that wasn't a lawsuit per se, but that was sort of their larger mantra and approach, was saying, we are not law violators. We are not conscientious objectors, for example. We're not violating the law in accordance with our religious beliefs. We're actually out there enforcing the law of the land, which is this ratified international amendment, and that we accept refugees, and trying to kind of put the federal government and the Reagan administration on trial as being the ones who were actually in violation of international law. So just throwing that out there as sort of an interesting history that could be relevant.
Thank you so much, Liz, for that response. Caitlin is going to answer a question from the chat.
Sure. So the question is, if we have recommendations for data privacy protections at the state level. And I'd like to say that I am encouraged by the privacy developments at the state and local level. This year, at least 20 states, I believe, have introduced comprehensive privacy bills. Connecticut and Utah have joined states like California, Colorado, and Virginia in enacting new data privacy laws. But especially when it comes to privacy in the context of abortion, I do believe that we need comprehensive federal privacy protections that apply to all states. And I do also think that there are many areas where federal law could improve upon even the state bills or laws that we've seen so far. And just as a few examples of trends, many state bills, proposed bills, or even enacted laws do largely exempt smaller businesses that don't meet certain revenue or size requirements or exclude nonprofits. But as we know, we have seen significant privacy and security issues coming from smaller companies as well. Even smaller organizations and nonprofits can process or share personal information in a way that could violate somebody's privacy when it comes to reproductive health. So I do think that this is an area that both state and federal legislatures would need to look at. Many state laws or bills do not have a private right of action. Even California's privacy law, which is one of the stronger ones, only has a very limited private right of action tied to data breaches. So if somebody's privacy was violated in a way related to abortion or their reproductive health, in many cases, they might not be able to sue under certain proposed bills. And finally, I do think that both privacy bills at the state and the federal levels will really need to look at secondary uses of data. I'm talking data sharing and uses, especially among information aggregators. Although many state bills or laws do impose data minimization, there are generally a lot of exceptions for what types of data or uses might either be categorically or conditionally permitted. And so I think that's something that both, ideally a federal law, but in the absence of a federal comprehensive data privacy law, for state legislators we need to look at as well.
Thank you so much, Caitlin. And we will be wrapping up in just a moment for our closing remarks, but to fit in one more question from the chat about pro bono legal support, and if that's available to individuals or private healthcare providers or others who might be targeted by police or prosecutors, and the idea that there might be a tsunami of legal action against individuals, and how we might, as collective advocates or different experts in the various professions, help people overcome these fears. Anyone want to talk about that? The idea of pro bono legal support or other ways we can help move things forward?
Yeah, I can hop in. Just a note of, and this kind of hits at a question before that we didn't actually weigh in, but I want to reflect on the various lawyers here and probably the many various lawyers watching this, that the main point here is that it is all hands on deck, and it is every type of lawyer actually will need to be engaged in this fight. And that it is a long one, and we can't forget the feeling we had on June 24th in 10 years, wherein we are still going to be fighting for a right, and in 20 and in 30. So I just want to be clear that I know people are very eager to engage now, and somehow write something to yourself that reminds you about that feeling as we all kind of tire out. It's very normal, but just to keep going, and that's part of the opportunities and future in activism, that creative rage, that is part of the work here, is to keep going. But that was a long intro to just say there are ongoing efforts of the coalition to set something up along the lines of the question. And so that there is an effort underway, and to note that if you're feeling like, I want to know what my pro bono, I want to be clued in or glued into whatever's happening, is that you're not alone, and that there are many who are feeling that way. And so there's just an effort of organizing and getting it all together, which is, all of y'all can understand is challenge, is the start. So but that is a great question. And if you live across the country, I really like what Professor Nourse said of this is not just a DC problem, and that's the whole point. And so I hope there are people from across the country on this call, and that, all of this in the end is going to be super local as well. And so, it's always good to see what's going on with your local organizations on the ground, and what is underway as you look forward. But the other final piece is it's unclear what this will actually look like, right? We're a couple of months in. Alabama just said that they are going to go after travel. So we don't know what this chaos is. And that's the point, is that it's chaos. And it actually is, the chaos is more just the fear it is inflicted into everybody about what is legal and what is not. And so just the note there that what is an actual case may come to fruition is different from the impact it's having in people's lives right now. And for lawyers, that can be frustrating because we're ready for the cases, but what does it mean when the law has this impact in everybody's lives right now that you can't touch, necessarily? So so maybe that's, again, to my earlier point, that this is a longer fight. And so appreciate the question. And I think there's ongoing efforts there.
Thank you so much, Leila. And I think you touched on this, but our final point in the Q&A, the idea that it's, can we have an all hands on deck approach that in addition to dealing with those cases as they arise, but the lobbying, elections, using the courts, but also protests, marches, and other direct actions, which, maybe we can develop further as people coming from different sectors working together. So thank you so much. And now I'm excited to introduce our Austin City Council member, who will be providing some closing remarks. And before I do that, just want to say one more time how much the Gender Justice Initiative appreciates all of our panelists, the expertise brought today, the insights, as well as the stories, and thinking of ways that we can use this to move forward, turning that creative rage into action, hope, and light that you all had mentioned before. So thank you so much, panelists. And delighted to welcome Austin City Council member José Vela for some closing remarks. Thanks for joining us.
Well, thank you so much for inviting me. I'm sorry that Vanessa is not able to make it. She had an emergency come up in the district, but I'm delighted to be here with y'all. I guess just to begin, let me tell you a little bit about myself. I am an attorney. I'm originally from Laredo, Texas. I've lived in Austin for about 30 years now. I am an attorney. I practiced immigration and criminal defense for many years before being recently elected to the Austin City Council. Started February 7th, so relatively new to the Austin City Council, but very excited to be here, and was very happy to get the Grace Act passed, which I'll tell y'all a little about. And just to kind of give a little bit of context, Austin has always been a center for reproductive rights activism. And there's a great article in the Texas Observer, a magazine that is called Rose Grassroots Beginnings, which talks about the University of Texas Law School, Sarah Weddington, and just student activism around reproductive rights in the like 1960s, 1970s. Great history of Austin. So when the Dobbs leaked decision came out, my staff and I mean, we had to do something. I mean, just here in Austin, we knew that there had to be a reaction, especially because of the context. Obviously, Texas is a very tough state for abortion rights. There are the old laws criminalizing abortion from, I believe, like the 1920s, where there was kind of immediately a debate about whether those would be in effect again. They have not been touched or used in 50, 60 years, and they're not even really codified anymore. They're not in the penal code, for example, anymore, but that's still actually an active debate, with our state attorney general taking the position that they are in effect again. Then, of course, there's a trigger law, which had its own issues and problems. And of course, then we also have the civil suits under SB 8. So, very, very difficult situation in Texas. We knew that if the Dobbs decision was released the way that it was leaked, that we were going to be in serious trouble. And so the question really just kind of became, what can we do as a city? What can the city of Austin do to protect abortion rights as much as possible? Then within that, there's some kind of important background and context too, because Austin has had a very difficult relationship with the Texas legislature over the last really multiple decades, starting with environmental regulation that Austin was passing in the 1980s and 1990s, which the state was trying to kind of preempt or at least dilute as much as possible, to more recently where Austin had lifted a public camping ban, essentially legalizing homelessness. And there was a reaction from the state, where the state didn't just kind of overturn Austin's change to its camping laws, but actually banned public camping statewide. And then again, with the protests and with the reimagining public safety trend, again, Austin reallocated funds away from the police department towards funding social services, and the state stepped in and again didn't just bar Austin from reducing its police budget, but passed a law saying that essentially no local governments in Texas could reduce their police budget. So we were working in a situation where we knew that the legislature was going to step in and block anything that we could do, that there was very high likelihood that the legislature would try to step in and try to block us. So we had to do something that was very kind of narrowly tailored, do as much as we could do on the local level, but not come into direct conflict with the state, where anything that we did would be either immediately overturned in the courts or potentially in the legislative session that's coming up. Actually, the Texas legislature only meets for 140 days every 2 years, but that's going to be happening here in January. So we kind of had one eye toward the Texas legislature, and with that, the Grace Act was born, and it's what what we did in that was kind of really try to thread the needle to say that the city of Austin is not going to fund any type of investigation or databases or anything like that with regard to abortion, with regard to the police investigating any types of abortion crimes. In other words, we said police department, we want zero funds toward investigating abortions. We don't want any task forces. We don't want any kind of databases. We don't want anything like that. And then the other element of the Grace Act was that abortion investigations, any kind of criminal abortion investigation, was to be the lowest priority of the Austin Police Department. And we were happy to see that go through. Thankfully, here in Austin, it's a city that's very supportive, and we had a 10-to-1 vote on the Austin City Council for the Grace Act, and that immediately went through. And from my perspective, it was very inspiring to see so many other localities, particularly those in more conservative states, adopt similar measures, and many times identical measures, word for word, in cities and other jurisdictions throughout the country. And the last thing I'll mention, we just were fresh off a automated license plate reader debate at last night's city council meeting, whereby the city of Austin is reinstating its automated license plate reader program. And I voted against reinstating the program after an amendment that I offered did not pass. It lost 5-6, unfortunately. But my amendment would have limited the data collection by the automated license plate readers, which are those little scanners that kind of grab your license plate as you drive around. Very commonly used by police departments all across the nation, but Austin had stopped their use a couple of years ago. I wanted to limit it to 3-minute data retention. In other words, I don't want any kind of historical kind of data retention. I just want them to be able to be used for a hot list. Ultimately, there was a 30-day data retention limit that was approved by City Council. But again, abortion was front and center as part of that debate, because while on the one hand, we understand that automated license plate readers can be useful in tracking down, missing or endangered people, or the felony kind of situations, emergency situations where they're looking for a vehicle, whether kidnappings or a fleeing suspect or something to that effect. There was a realization that these can also be used to gather information that we would then have to potentially turn over to other counties, to other law enforcement agencies that could be used to prosecute women who are seeking abortions. So it's interesting how the abortion becoming illegal in the state of Texas has now really changed so many people's perception of what criminal law is, and what how far we should take it, what the role and the power of the police department is. It's really, I think, reignited a very vigorous debate about civil liberties, civil rights in Texas in particular. So that's kind of the short version of what we've been doing here in Austin, and happy to answer any questions, or also just hear any thoughts and reactions from y'all.
Thank you so much, Councilmember Vela. Opening it up for a moment or two of questions or reactions. Anna Rupani had commented that Austin really is on the front lines supporting Texans. So thank you for all you're doing.
It's my pleasure, and I don't know how well y'all know Austin, but there was a Waco city councilwoman who pushed for the Grace Act in Waco, a very conservative city. Again, it's been inspiring to see so many cities where you would not really expect them to take up the mantle of abortion rights, and they've done so, and they've done so unabashedly. And the conversation, just abortion being now a crime in Texas, has just completely changed the political conversation in Texas. There is a kind of a complacency, to a certain extent, that can develop, but this, I think, has really awoken everybody up. And obviously, the abortion is front and center in the Texas gubernatorial race, which is up in November, and very, very hot issue, and changing people's attitudes, and really just making people reconsider, how they view and engage with politics.
Well, thank you again for being with us and for your remarks to close out this day-long conference. We really appreciate not only your work in Austin, but as a capstone for the work that we've heard about today from everyone. So thanks for joining us.
My pleasure. My pleasure. Thank you all so much for inviting me and for having me.
Thank you. And now I'm delighted to turn it over to Melissa Hafaf, who is our director of the Georgetown Gender Justice Initiative. Melissa.
Can you all hear me? Can you all see me?
We can hear you. Yes, and see you. Thank you.
Okay, great. Hi. Thank you all for being with us. I just wanted to close this conference and say a few thank yous to our participants. Thank you so much for attending this day conference. We hope that you got to deepen your understanding of the critical situation that we're in, but also that you got inspiration to and ignite your creative rage to join the movement, or the movements, I should say. I'd like to also thank our 26 speakers today for taking the time to be with us, to share their expertise, their insights, and for being so inspiring to fight back, knowing that, again, the situation is extremely challenging and will continue to be. And as Leila said, it's a very long fight, so we need to be ready for that. I'd also like to thank Kyle for his support all day with all this tech stuff. Thank you so much. Our ASL interpreters, Leah, Emily, Aviva, Leah again, Luna. Thank you so much for being with us and interpreting our 3 panels today. And last but not least, I'd like to thank my team, the Gender Justice Initiative, and particularly Deborah Epstein, Naomi Mezzi, Kristi Graves, Dion Coker-Apia, Nadia Brown, Denise Brennan, and Sarah Omar, who helped bring this incredible conference to you. And we hope to see you at more events. We have a lot of things coming up with the GJI related to reproductive justice, but also many other issues that are connected to gender justice at large. So feel free to go on our website and join our mailing list so you can get all our events, our news, and all the different programs that we put together. Thank you all so much. Have a wonderful afternoon and weekend. And we hope to see you soon.
Melissa, you were not here this morning when I introduced you, and I just want to take this moment to thank you for the amazing work you've done as Executive Director of Gender Justice Initiative at Georgetown. Thank you.
Thank you so much, Melissa. Thank you, everyone. My pleasure.